The topic that is the father of the loser in family law. I think I agree with everyone here that it's a very controversial topic. I think it would have been better to ask, is the child the loser? And I think everybody here agrees that the child is and has been the loser. Now, just so you can concentrate on what I'm saying and not my glasses, these are magnets. Some of you in the audience may wonder how it came about on this important issue, that there's only one woman and all these guys sitting at the table on a topic that so seriously impacts on children. The organisers had hoped for a more balanced view, but because of what I believe are the inherent disadvantages and inequalities of women in our society, it turned out that once again the interests of men are being represented more fully than those of women and children. I've looked at the forum site of some of the men's rights groups represented here today and found a disturbing element of anger, control and hatred of women. The word feminist is used as if it means liar, man-hater or hysterical female. I'd like to say, and make no apologies for it, that I am a feminist. This doesn't mean I'm hysterical, but that I seek to redress the inequalities women face regarding income levels and representation in government and public life. I don't think anybody could dispute that. Nor does it mean I hate men. I love men. How could I not? My 29-year-old son is a man. What I do abhor and seek to also address tonight is the power violent and controlling people have over small, vulnerable and innocent children. While we all agree that shared parenting is the ideal in an ideal world, the facts are that the latest research shows that where there is entrenched conflict, shared parenting puts too great a burden on children of the partnership. Those who know the family court list will also know that the cases which end up there are those which involve the highest level of entrenched conflict. Under the current shared parenting law, what we do know, which is there for all to see on the family court website, is that parents the court itself has deemed abusive and violent are still awarded access to their children. In cases where less than 30% care was awarded to fathers, in 29% of those cases, this was because, and I quote, abuse and family violence. When mothers were awarded less than 30% care, this was the reason in 16% of cases. This means that in litigated family court cases in 2007 and 8, 267 fathers and mothers were awarded some care of their children even though the court deemed them to be violent. Extrapolating from that, given that the Federal Magistrate Court deals with 97% of cases, there are 2.16 children per household, and this covers just 1 year, we estimate there are at the very least 15,000 Australian children being forced to have ongoing contact with a parent the courts have said are violent and abusive. Some of these contact visits are supervised. Why, I would like to ask, are abusive parents being subsidised to the tune of $180 an hour by you and me, the taxpayer, to be given the opportunity to terrorise their child for an hour or more a week? As one grandmother wrote to us, my grandchildren told the court psychologist how they had to watch their father bash their mother, spit on her, drag her around by the hair and kick her with steel-toed boots just after she'd given birth, and then the court said to go and sit at the contact office and have a meaningful access visit. If a parent cannot be trusted to be with a child without supervision, they should be ordered by the court to attend parenting courses, anger management or some other treatment to address their behaviour. The Safer Family Law campaign has tried hard to keep all our language gender neutral. We have invited the men's rights groups, many of you here today, to attend our rallies with us. We want your help in trying to protect children from violence and abuse. My emails have gone unacknowledged. Yet I find it difficult to believe that you don't share my concerns about the physical safety and psychological and emotional well-being of your children. However, reading some of the forum comments on your websites, I can see that many of your members are damaged. So many of us have been damaged from our own abusive and neglectful childhoods, myself included. I fully support anyone in their attempts to address these issues in their lives and heal from their own violence and abuse. But these issues need to be acknowledged to be addressed. Disseminating hate and supporting members of your groups who have these anger issues does nothing to help them or their children. In fact, it only further damages both. Instead of addressing abusive behaviour, many of the men's rights groups have been able to disseminate, without credible supporting evidence, that most allegations of abuse in custody proceedings are false. There is much peer-reviewed evidence, which I'm happy to send anyone who puts their name on a sheet at the back of the room, that more than 90% of allegations of abuse in custody cases are true. We have a sample of 6 studies. However, one is an Australian study by Professor Thea Brown from Monash University, Social Work and Human Services. Results of this study showed that abuse in Australian family court cases was real, that it was severe and serious, and the courts and child protection services did not provide services for the families. Another study from the University of Toronto in 2004. Results of this analysis showed that neglect is the most common form of intentionally fabricated maltreatment. While anonymous reporters and non-custodial parents, usually fathers, most frequently prompt intentionally false reports. Of the intentionally false allegations of maltreatment tracked, custodial parents, usually mothers, and victimised children were least likely to fabricate reports of abuse or neglect. This is the most important and thorough research testing done on this issue. Men's rights counter that they were biased in their approach. These 2 researchers are academically qualified men who are well respected in their fields, as demonstrated by the peer-reviewed publication of their findings, revealing the existence of child abuse in the context of marital breakdown and custody and access disputes. And yet, because groups representing men have had the ear of the media for the past 15 years, a recent public survey, which I think one of you mentioned, perhaps you, Mark, indicated that when asked if allegations of abuse in custody cases was false, 49% of the public said yes, and 25% said they were not sure. This means that 75% of the public are prepared to believe that most allegations of abuse in custody cases are false, which is completely contrary to all the research. This is what led to the shared parenting amendments, which the Chief Justice of the Family Court said in a letter to the Attorney General in early May, when we held our national rallies, that the amendments discouraged parents from raising allegations of abuse, and that urgent changes were needed to the Act to address this problem. So the 15,000 children forced into contact with abusive parents mentioned above is only the tip of the iceberg. It represents only those deemed by the court to be violent. Then there are all those who were told by their lawyers not to raise allegations of abuse. I've seen photographs of welts on a 4-year-old girl's back, which one of our parents showed her solicitor, only to be told that it would be unwise to produce this in court. Why not? Asked the mother incredulously. Because you will risk losing your child if you do, was his reply. The photographs remain in a drawer. If parents do raise allegations of abuse and can't prove it to the satisfaction of the court, sexual abuse in particular, but even violence is extremely difficult to prove, they must pay both costs and risk losing custody of their child. That's enough to scare most parents off, even raising the allegations.